Meantime, prosecutors were ready to throw the book at a gang of bikers who made worldwide headlines in September, brutally beating a driver in a vicious attack in New York City, hauling him out of his Range Rover right in front of his terrified wife and young daughter. But now prosecutors have decided to lessen the charges because the victim is healing so well. Well, let's go now to Nolan Klein. He is a trial attorney who's going to give us some insight on this. Great to see you, Nolan.
Thank you. Nice to see you, Gretchen.
All right. So it's my understanding that the charges have been reduced because there's a difference between permanent injury and a different kind of an injury?
That's exactly right. The charges here have been reduced because the charges that were originally brought, which were really the maximum that the prosecutors could bring, required permanent injury or disfigurement. It turns out that Mr. Lee and the victim, his injuries are healing in such a way that the prosecutors really can no longer in good faith claim that he's been permanently injured or disfigured. Of course, I, like everybody else, would like to see these guys just have the book thrown at them. They're the worst kind of people. They did the worst kind of thing anybody can imagine. They took a man out of his car in front of his wife and kid, and they beat him, and it's horrible. But it's also the responsibility of the prosecutors, like any lawyers, to not engage in emotional satisfaction, but to engage in activities that will actually produce results.
Well,
and in this case, yeah.
Well, I was just going to say that also don't they have to choose charges that actually might bring a conviction if you're on the prosecution side, and if the injuries are not permanent. So I guess the difference here is that the jail time used to be up to 25 years. Now, if convicted, it could be up to 15 years, right?
The jail time used to be up to 25 years if they were convicted of permanently disfiguring him. Now that it seems that he hasn't been permanently disfigured or injured, the jail time would be up to 15 years. I'd imagine there's going to be a plea at some point anyway, and that they wouldn't have gotten 25 or 15 at the end of the day, no matter what. However, in order to bring the charges, the prosecutors do have to have a factual, good faith basis for the charges that they bring. And with the injury not being permanent, it seems that the only good faith charges that they can bring now are the reduced charges that have the 15-year maximum. And again, if you bring a charge that's inappropriate or that's really overreaching, you risk losing the whole case. And in the case like this in particular, that is the last thing that anybody wants to see risked.
Okay. Thanks so much for clearing that up. Now, in the meantime, Target facing mounting lawsuits over that massive security breach that exposed 40 million Americans to potential credit card fraud. So, Nolan, I believe now it's over a dozen, 15 lawsuits seeking class action status. What are they going to try and claim? Is this a potential loss of money because somebody uses their credit card, or are we talking about identity theft here?
Well, there's a couple problems as I see it with the lawsuit, and I myself have sued Target multiple times as a plaintiff's attorney, and I've been involved in many class action suits. A few months ago, I was named class counsel by a federal judge for an 80,000 person class, and I just don't see this as a class action case. I don't see how the attorneys that are filing all these lawsuits get around what's called the typicality element. Typicality means that every member of the class has to have the same damages. In this case, from what I can see so far, some people have been injured, some people's cards have been used, some people's haven't, some people have been maybe exposed to identity theft, some haven't. Even of those whose cards have been used in a fraudulent way, it's all different amounts. Some have been reimbursed by their banks or by the credit card companies, some haven't. And so the damages that people have suffered are just so diverse, they're just so different, that I just don't see any way that this would ever be approved.
But what about consumers who have a reasonable expectation that a business will take precautionary measures to make sure that they have the most up-to-date, security-enhanced kind of equipment, which in this case, it appears that almost all U.S. stores don't because of the kind of credit cards that we have here in the U.S.?
That's exactly right. We're still using the magnetic strips. In Europe, they changed over to the electronic chips a long time ago, which apparently are much, much safer than the magnetic strips. We're still using those. Who's responsible for that? Whether it's the card issuers, whether it's a government regulation that needs to be changed, I don't know. But certainly the types of cards that Target was taking in are the types that comply with what is being used still nationwide, perhaps antiquated, but still being used in our country today. And as far as the actual hacking, the question is whether Target could foresee that something like this would happen. Otherwise, we have an intervening criminal act for which Target really can't be held liable. Wow. And we really need to know more about what it is that this hacking was all about. It was apparently very sophisticated. We still don't know all the details. If it was something that Target perhaps should have foreseen and could have prevented reasonably, then yes, there may be civil liability there, although the exact procedural mechanism I don't think is a class action. If it's something new, if it's something new and complex, there may not be liability.
All right, we'll have to wait and see. It's still in the beginning of the investigation. Nolan Klein, thanks so much for your time.